Okay. Thank you. Go to enforcement staff next. I understand we have 2, and then I'll wait for the speaker cards for after that.
Good morning. Good morning, Madam Marcus, Chair, members of the board. My name is Yvonne West. I'm a senior staff counsel with the Office of Enforcement representing the State Water Board prosecution team on specifically item number 7, which is the Lincoln Avenue Water Company and the proposed order for violations of the MPDS permit, which was issued by the Los Angeles Regional Water Quality Control Board. Just generally, I want to state that the prosecution team concurs with the proposed order, the statement of background facts in that order, the summary of the applicable laws, and the conclusions reached in the proposed order, and we support the adoption of the order as drafted. I do, however, want to briefly address the written comments which were submitted by Mr. Turner on behalf of Lincoln Avenue Water Company, to make myself available and Ms. Erin Mustaine available for any questions that the State Board may have for the prosecution team. And in addition, after I'm done, Ms. Okamoto from the Office of Enforcement is here to address some of the more general issues that go over all 3 of the orders before you, the mandatory minimum penalty orders before you, that were submitted by members of the public, not the specific parties at issue. And she's going to come up after me. Lincoln Avenue Water Company raised the affirmative defense of single operational upset for the first time at the hearing on this matter before board member Spivey Weber. And this affirmative defense was raised again by Mr. Turner on behalf of Lincoln Avenue Water Company in his comments on the proposed order that's before you. And I just wanted to focus on one nuances of that defense that was highlighted in his comment letter. And specifically, I want to make the point that Lincoln Avenue Water Company does not qualify for the single operational upset reduction because the violations at issue were caused by a knowing and intentional change in the treatment process. Mr. Regan has described to you what those changes were and the result of those changes that had given rise to the violations, which are the basis for the mandatory minimum penalties, which are being sought to be imposed by the order before you. Lincoln Avenue Water Company doesn't dispute the factual cause of the violations, but asserts without legal support a need to demonstrate an intent to cause the actual violations. And I just wanted to go on the record as strongly opposing that view and pointing to the clear language in the EPA guidance document, which is also cited in the State Board Enforcement Policy, that makes it clear that the intent is not to violate, but that the intent is to do the act which results in the violation. There's a knowing and intentional act here. It was the knowing and intentional changes that were implemented to the treatment process, the intent being to comply with new effluent limits, the result being that other limits were violated. I think that the EPA guidance document makes it clear that the single operational upset reduction is not available in situations such as here, where the act that gives rise to the violation are the result of an intentional act. For the reasons that I've touched on and for the reasons that are discussed in depth in the proposed order, Lincoln Avenue Water Company does not qualify for the single operational upset reduction, and the prosecution team urges and supports the adoption of the order as drafted. And with that, I'm going to allow Ms. Okamoto to come forward and address the other issues.
Hello.
Thank you. Good morning, Madam Chair and board members. My name is Mayumi Okamoto. I'm an attorney with the Office of Enforcement. I have some general comments that I want to make on items 7, 8, and 9, specifically with the issue of the latches defense.
Thank you.
The prosecution team agrees and supports the analysis and conclusions in the proposed orders, and specifically on the issue of whether latches can be invoked to mitigate mandatory minimum penalties, or MMPs is how I'm going to refer to them. In 2000, the legislature enacted these provisions out of a concern that the boards were kind of failing at one of the core missions to enforce Clean Water Act violations. And as Mr. Wiles stated in his comments, the MMP provisions in Section 13385, they differ from other penalty provisions in the Water Code in that they remove the board's discretion to assess penalties if it's determined that these specific types of effluent limit violations and NPDES permits, if it's determined that those have occurred. Unless the discharger is able to successfully demonstrate that one of the statutorily recognized affirmative defenses in 13385J1 applies, then the MMPs must be assessed. And the board examined this question regarding the mandatory nature of the penalties as well as the affirmative defenses in 2007 with the consideration of a petition that was filed by the Escondido Creek Conservancy. The proposed orders before you today examine the equitable defense of latches in two specific ways. First, they address whether the defense is available in the context of MMPs as a matter of law. So the prosecution team agrees that where MMPs are at issue, latches is not a recognized defense to penalties, as this equitable defense cannot be asserted to override a statutory mandate to assess them. Doing so would be contrary to the plain reading of the statute and would enlarge the scope of the statutorily recognized defenses in 13385 subdivision J1. And it would also circumvent the board's mandatory duty to enforce specific NPDES permit violations and assess MMPs. The commenters from CASA and Riviera West, they've both relied upon a Superior Court opinion in the writ of mandate proceeding for Tehama Market versus the Central Valley Water Board for the proposition that latches is available as a defense to dischargers and that it clearly applies to administrative agencies. And I just want to point out that there is an important distinguishing fact between Tehama Market and the matters that are before you today. The violations at issue in Tehama Market were violations of the 1999 Construction General Permit, which are subject to discretionary penalties and not mandatory minimum penalties. So the commenter's reliance on Tehama Market is not entirely on point. The issues before you today, they're narrower in scope in that they only examine whether latches is available as a defense to override the board's mandate to assess MMPs. The board is not being asked to opine on the broader issue of whether latches is available as a defense in matters involving discretionary penalties. Even if the board decides that latches can be invoked, we agree that with the second analysis in the proposed orders that as applied to the facts and the specific evidence in the record, that the dischargers cannot establish a manifest injustice or unreasonable delay in prosecuting the violations. However, it's the prosecution team's position, and we would assert that the board need not reach that question whether latches applies on the merits, because it's our position that as a matter of law, they cannot be applied to override a statutory mandate. Thank you.
Great. Thank you very much, Ms. Okamoto. All right. I have two speakers. The first is Melissa Thorm for various clients.
Good morning, Madam Chair and board members. I have two topics that I want to talk to you about generally today, and they don't apply to any particular order, but more generally to all four of the orders, because as I pointed out in my comment letter, a lot of the language is verbatim from one order to another, and so I just wanted to raise the issues more on the precedent that's being set by these orders. So the first topic is about stale enforcement and going after things that have been sitting for a really long time. And I wanted to give you this citation that I had put in my letter from the U.S. Supreme Court saying that it would be utterly repugnant to the genius of our laws if actions for penalties could be brought at any distance of time. And it further stated that in a country where not even treason can be prosecuted after a lapse of 3 years, it could scarcely be supposed that an individual would remain forever liable to a pecuniary forfeiture. So basically, they said, if you can't go after somebody for treason after 3 years, why should you be able to go after penalties and monetary penalties? The Attorney General is not allowed to go after things. If the Water Board gives a penalty action to the Attorney General, they have 3 years. They can't go after it after 3 years. EPA and citizen suits have 5 years. So for NPDES permits, generally, you can't go past 5 years. The enforcement policy that you all have adopted talks about swift and timely enforcement, and specifically stated in the 2002 version that MMPs should be brought within 7 months of the time that they are found to apply. And that was later backed off a little bit because of the backlogs that we were seeing at the regional boards to 18 months in the 2010 version. But that means the first time that you know that there's an MMP within 18 months of that, you should be issuing an administrative civil liability order. Here, some of these are going all the way back to 2000 to look for MMPs. And we just think that that is wrong because it's beyond the period of time that the statute of limitations would allow for someone to go after it. And under the case law, prejudice is presumed in that case. If you can borrow the statute of limitations that would apply, you're presuming prejudice to that party. And these orders basically ignore those policies, and there's other case law that I cited where there are mandatory issues where latches is still being applied, the Fountain Valley case that I cited, where there was mandatory overpayments that hospitals had, and they were still allowed to use latches. So we would request that these 4 orders not have these overarching determinations that you can never use latches in an MMP case. I would much rather that that door remain open in a case where there's severe prejudice and undue delay, that people could still make that argument. And at the very least, we would like these orders to not be precedential. You could still adopt them, but say that every case is going to be case specific and we want to have that door open. And the other issue that I wanted to raise today was about going into closed session for deliberations on adjudicatory hearing matters. And I put forth some legal reasons why I think that under Bagley-Keene it's not allowed, because you're not really subject to Chapter 5, which would be the only way if it's not a personnel matter or something else that's specifically laid out there. We're supposed to have government in the sunshine as much as possible, and we'd really like deliberations to be in the open. Thank you.
Next speaker is Adam Link, Director of Governmental Affairs for CASA.
Good morning, Madam Chair and board members. Thank you for the opportunity to speak. If this were a legislative hearing, I'd probably just say me too, as to what Melissa said. But I do want to briefly comment on...
I want to say we are making you stand up, I know, but we're not making you stand up and leaning over to the side, like in legislative hearings,
Like
where
this?
you just say
Much
me
better?
too. You may say your piece, please do.
I appreciate it. Thank you. I do just want to briefly comment on the 4 proposed orders that are before the board today. Similar to Melissa's comments, CASA's concern isn't necessarily with the substantive allegations that are in the orders, but more with the extended delay that are associated with these actions and the discussion of latches that are contained in each of these, excuse me, these orders. As we noted in our July 11th comment letter, there are delays of 6, 9, and 10 years between some of the acts giving rise to the alleged violations and the actual initiation of enforcement. And as Melissa noted, these exceed what would otherwise be the relevant statutes of limitation of 3 and 5 years, and also the guidance in the State Water Board enforcement policy, which recommended 7 months and then 18 months respectively. So there's a significant gap of time between those two. As a result, these entities and others that might be similarly situated in the future have more than a fair argument, I think, that the equitable doctrine of latches would apply in their individual circumstances. And again, not that that these entities have proven it in this case, but that doctrine and that it should be available to those in these circumstances in the future. Unfortunately, each of these orders contains provisions which expressly state that the water boards do not have the authority to invoke latches when imposing mandatory minimum penalties. And while we may disagree on the legality or the analysis underlying that assessment, what's more important is that these don't need to be in these particular orders. These discussions about the availability of latches aren't necessary to reach the individual results in these particular cases. And so we would ask that, or strongly urge the board, to reconsider and reject those portions of each order that seem to disallow a latches argument generally, and that discuss the doctrine's kind of general applicability to enforcement actions and MMPs. And also similar to what Melissa said, in the alternative, we would ask that the board make these portions of the orders that relate to the general applicability of latches non-precedential in nature. And so I thank you for the opportunity to comment and be happy to answer any questions.
Thank you. I just have one question, and it would apply to Ms. Thorm too, so feel free to come back up. If our decision is that we don't have authority because of the way the mandatory minimum penalty law is written, why would you want us to make it non-precedential, just so we could have this same argument another day versus you, your clients, or someone else going to the legislature to ask them to change it?
And Melissa may be better poised to answer that than I would, but I would say that if that portion of the order is not precedential, at least it would allow those in similar circumstances in the future to bring up that argument. So yeah, it does preserve it for.
But we would end up having the same,
Most likely, yes.
I think. Okay. I'm just trying to understand the reasoning there as opposed to wanting to go for it now. Thank you. Melissa, do you want to add anything to that, just so I understand?
Well, I just think it might avoid having to go to the legislature if we don't make that decision. I think that there is case law that I provided to you in that Fountain Valley case, if you look at it, where it was a mandatory statutory requirement and they still applied latches, so I don't see how that really is any different. Latches applies in many, many cases, in criminal cases where it's a mandatory sentencing or things like that where they've waited too long. So I don't agree with that part of it, but if it were precedential, then I think, yeah, we're probably going to try to go get some kind of either exception to the mandatory minimum penalties rules for that to make it more consistent with the enforcement policy, or just generally have some kind of administrative statute of limitations.
Thank you. Now, I want to turn, and I don't know who, either Mr. Reagan, Mr. Wiles, Mr. Lawfer. I want to give you an opportunity to respond to the specific comments about the case, the Fountain Valley case that Ms. Thorm talked about, and then also about the closed session issue.
Okay. First of all, with respect to the Fountain Valley case, my recollection of that particular case, Mr. Regan or Mr. Wiles can supplement if need be, it was an issue of a general obligation in order to go back and seek recruitment from overpayments. And there was not the specific mandate imposed with a very specific calculus. There are very different issues associated with, for example, how you go about determining and documenting and seeking those kind of overpayments, whereas here you had a legislative history that not only results in clear statutory language that imposes the affirmative duty on the water boards to seek a mandatory minimum penalty and to recover a mandatory minimum penalty for a specific violation of certain NPDES effluent limitations. And you couple that with the discussion from the Brentwood case of the legislative history and the expectations that the legislature had for the boards to pursue and complete these, and I don't think Fountain Valley provides a good analysis. In addition, simply put, the order was not, or the issue was not joined in the Fountain Valley case to the way that it is here, where there's a clear conflict between, if you will, the equitable principle of latches and the mandatory duty imposed upon the water boards by the legislature through Water Code 13385. With respect to the closed session item, as the board members are aware from prior meetings, I mean, first of all, Bagley-Keene, the specific subdivision of Government Code Section 11,126, Subdivision C3, doesn't just refer to Chapter 5. It says, or other similar proceedings. And here you had an evidentiary hearing that is similar to a Chapter 5 proceeding. In prior cases, the courts have determined these types of proceedings are formal proceedings. We're not proceeding informally under the special provisions of Chapter 4.5 of the APA. And just as this board holds closed sessions on water rights hearings you're entitled to do that in this particular context.
Thank you for that explanation for the record. I also have a, Chris, you didn't need a card, but it was helpful to let me know you wanted to speak. Thank you.
I agree with the points that Mr. Lawfer raised, with one addition. Excuse me, 4 times since the mandatory minimum penalty statute was enacted, the legislature has revisited the issues associated with it and amended it. They amended it as recently as 2010. If they wanted to add a laches defense, they could have done it on any of those 4 occasions, including as shortly as 3 years ago, but they didn't. That's all I want to add.
All right, thank you. All right. Any questions or comments from the board? Anything else any of you want to say? Do I have a motion?
I move we adopt this order as amended.
Good memory. I'll second the
I
motion.
have a second. All in favor?
Aye.
Aye.
Any opposed? All right. Thank you all for your time. Orders are confirmed. Or any other word I should
No,
use.
we need to do the other 2, don't we?
Oh, this one is, right. I'm sorry. Didn't mean to do it. I meant to do them all at once. Sorry. I got
Well,
my order.
I can go ahead and move that we adopt the order number, item number 8 for a mandatory minimum penalty against Lubricating Specialties Company for violations of Los Angeles Regional Water Quality Control Board number 97-052 and R4-2006-0065, and item 9, the order imposing a mandatory minimum penalty against Rodeo Owner Corporation for violations of the Los Angeles Regional Water Board's order R4-2003-0111.
Thank you
And-
for actually saying those things so that I didn't have to. But I also want to give the opportunity for the speakers, despite my request to try and speak on the first matter. You are certainly welcome to come back up on the items you mentioned, and staff, if there's anything else you want to say on these. We've all read it and been fully briefed, so we're definitely not giving short shrift to this
Yeah, and
item.
certainly-
What's your preference?
Well, my recommendation would be to, we did have the 2 commenters as well as the Office of Enforcement. If there's anything supplemental, as you just invited them to come up. Otherwise, certainly their comments were fairly generic, and the record can reflect that they are incorporated into item 8 as well as item 9. I would prefer that the board vote separately on each item so that there is a clear record of what's going forward. So I would first suggest that you ask Mr. Link and Ms. Thorm, as well as the prosecution team, whether there are any additional items they have on item 8, and then entertain the motion on that item, and then do the same thing for item 9.
Thank you. All right. Okay. Do you want to come up or no? You were just smiling. No. This is one of those things also in different cultures. This means no and this means yes. It just really depends, Can't use that. Sorry, I just got it. I know that because of you. In any event, that's just an aside. I won't say where that comes from. All right. Well, then let's take them in order. We have a motion on the item number 7, Lincoln Avenue Water Company.
We voted
And a second.
on that.
What?
We voted on that one, though.
You did vote, but I then got stopped. So did we close that vote? Do you feel like we
Yeah.
did that? All right.
We closed item 7, so now we're on item 8.
Terrific. Okay. Item 8, do I have a motion? You made the motion on both of them. Do I have a second on item 8?
I'll second the motion on item 8.
All right. Any discussion? All right. All in favor?
Aye.
Aye.
Any opposition? All right. That one is ordered. Item number 9, I have a motion. Do I have a second?
I will second the motion on item 9.
Any discussion? All in favor?
Aye.
Aye.
Any opposed? All right, that is confirmed. Thank you very much. Thank you, staff, and appreciate everyone's time. I know the mandatory minimum penalties issue is a challenging one, but we'll just note that the whole reason for the statute is that the board was perceived to be using its equitable authorities too cavalierly. So the intent was to tie our hands so people can proceed with it as they will. Thank you very much. We'll now move on to the next item, which promises to take most of our time. We have two related items. We'll start with the first one. We do have a time estimates, or actually requests for the panels. We've had some requests for what order people want to present in because of the timing. And thanks. As you set up, I'll let Ms. Wadhwani present the item. But just know that we've come up with an order, but we've also, to deal with the fact that some people, different people wanted to have the last word. Have you changed it? You'll read it out, yeah, okay. We've actually added a rebuttal period. It'll be very short so that everyone actually does have a chance to respond to the people who have come before. It's a very complex issue, a lot of moving parts, a lot of strong feelings, so we've added a 5-minute rebuttal period for the parties, not for the public, either panel or commenters, but for the parties to be able to have a series of last words at the end of our hearing. We will not be making a decision today. This will be, on this item number 11, we'll be taking in your good thoughts, as we have in the prior hearings on this matter, and then consider what revisions, if any, we might make to our proposed order. And with that, I'll turn it over to Ms. Wadhwani to explain it.
Thank you. Good morning, Board Chair and Board members. I'm Amel Wadhwani, Senior Staff Counsel with the Office of Chief Counsel. I'm here with Phil Wiles and Darren Polhamus. I am going to start by providing some brief background on the petitions and the proposed order, as well as some information on the process for the workshop. And I will also give the order for the workshop at the end. We are holding this workshop to take comment on a proposed order resolving petitions on a contested waiver of waste discharge requirements for agricultural discharges issued by the Central Coast Water Board on March 15th, 2012. The State Water Board received 5 petitions challenging various provisions of the Central Coast Agricultural Order. Last summer, the State Water Board reviewed the stay requests filed along with 2 of those petitions and adopted an order on September 19th, 2012, granting the stay requests in part and denying in part. The current proceedings are on the merits of the petitions. The State Water Board issued a letter on September 17th, 2012, informing parties that the petitions were complete and requesting responses to the petitions and filing of the administrative record within 30 days. The State Water Board subsequently extended the filing deadline for the responses to October 1st, 2012. After receiving and reviewing the administrative record and responses, the board issued a proposed order resolving the petitions on June 6th of this year, with a deadline for written comments by July 16th. The proposed order, which is the subject of this workshop, upholds the Central Coast Water Board's agricultural order in many respects, but not in all. I am not going to go into any detail now about the specifics of the proposed order, but pages 54, 55 provide a summary of exactly what it upholds and what it changes. We received a number of written comments. Those are posted on the State Water Board's website. Today's workshop is an opportunity for interested persons to address the board and comment orally on the proposed order. Before I provide more information on the workshop, I want to talk briefly about the projected schedule for adoption of the final order in this matter. The September 17th, 2012 complete petition letter triggered a 270-day time period in which, under our regulations, the State Water Board must adopt an order resolving the petitions or have them deemed denied. The regulations allow for the parties to agree to a 60-day extension. In this case, the parties did agree to a 60-day extension, which set the deadline for resolution of the petitions on August 13th, next month, 2013. Following today's workshop, we will revise the proposed order in accordance with board member direction. We expect to circulate a proposed final order for a brief written comment period on any proposed revisions, and then bring it back to the board for adoption. At this point, depending on the scope of the revisions we'll be making, we expect to bring the proposed final order to the board for adoption, most likely at the first September board meeting, but in no case do we intend to delay an adoption meeting past October 1st, 2013. There will be several weeks between the August 13th deadline set by our regulations and the resolution of the petitions potentially. Because of this discrepancy, we have proposed that the State Water Board take up review of the agricultural order on its own motion as permitted by the regulations. The board will consider that proposed own motion order with the next agenda item. Before turning to the order of today's workshop proceedings, we want to touch on one additional issue. As the proposed order states, we consider the agricultural order as proposed to be revised to constitute an interim approach to regulating agricultural discharges, and we intend to look to an expert panel that the State Water Board is currently in the process of convening for guidance on long-term statewide approaches to regulation of agricultural discharges. We received a number of comments asking for more specificity on the composition and the mandate of that expert panel. Although we think it may be premature at this point to provide precise information about the expert panel in the proposed order itself, I am going to turn this over to Darren for a few minutes to provide a brief description of that process now.
Oh, thank you. Good idea.
Good morning. Barely. Darren Polhemus, Deputy Director here at the State Water Board. And so I wanted to just give a thumbnail sketch of what we're anticipating for the expert panel. First, I want to kind of basically remind you that this panel, while being basically explicitly expressed in this petition order, we intend the panel to address two other issues as well. You will recall that the Water Board submitted a nitrate report to the legislature, and in that report there was a recommendation for experts to be convened and a panel to be formed specifically addressing nitrate issues. So this panel will encompass that as well. And then while we're at it, we'll open it up to just general irrigated lands regulatory program or irrigated field type of regulatory controls system. So it's really intended to address all three of those, which is obviously a very broad topic, but with some specifics. So as this order will specifically pose questions, those will obviously be directed to the panel, the questions that were posed in the nitrate report, and then as I discuss a little bit further, there'll be obviously opportunity to add more questions that the panel will address as well. So currently, I'm working to secure a contractor to assist the Water Board in basically managing the panel, information prep for the panel, and the whatnot, and that contract is not finalized yet. We're still finalizing on the scope of work and observing what goes on here to make sure that we include everything associated with that we need to in the contract so that it can basically address where we go. Let me give you at least the way we envision the scope of work now for the contractor. Right now, what we're proposing is that the contractor would do some initial survey work amongst all the different communities and stakeholders that are associated with the Irrigated Lands Program, the nitrate question, and the question specific pending this petition order. And basically prepare a brief summary. This is really prep for the panel members instead of saying, surprise, you know, you've got a big list of things to talk with here. So it's really kind of prepping up for that. Also, we want the contractor to do two other upfront items. One would be to recommend to the State Water Board the composition of expertise that should be solicited for the panel, as well as then potential candidates that may occupy those seats. And we want them to base that also on their, basically their survey findings, as well as we will invite from the public public comment and public recommendations associated with what they believe should also be in the contractor will incorporate that in their summary report and then submit that to the State Water Board for final approval. I'm not going to try to confuse you here, but what I'd also like to do on top of this is form an advisory committee, which will be an unofficial. It's not really contained in the contract explicitly for the responsibility of the contractor, except that they will provide support for an advisory committee. And the advisory committee, as we kind of envision it now, we would solicit, again, representatives from all of the known stakeholder groups that would like to participate. And really, the advisory committee would then provide input on the questions we take to the panel, and as well as provide recommendations for experts and maybe comment on whether a particular party has a particular problem with an expert. Obviously, we want the panel to be as unbiased as we can, and whatever is perceived to come from as their recommendations to not be biased or perceived as biased in one way or another. So we'll also solicit that from this advisory committee that we'll form to help us as we go through the panel process. Then the panel, basically, once we've composed them and basically have announced who they are, we will hold, at least at this moment, planned for 3 public meetings to take public comment on the questions that have been presented to the panel, so that everybody gets a chance to weigh in before the panel does any deliberations. Right now, we'll hold one in, I'm anticipating Sacramento, San Luis Obispo, and then somewhere in the San Joaquin Valley would be the 3 locations that we're considering at the moment, and obviously that's open for comment or suggestion as well. After the 3 public meetings, the panel would then basically convene. We are going to operate the panel under Begley-Keene, and so they will deliberate in public, and anytime there's a quorum of the group to get together, we will basically notice and make sure that the public's noticed of when those meetings will occur. Ultimately, the panel will deliver a draft report. This draft report will be released for public comment. We will then take the public comment, and the panel will consider that basically in preparation of their final report. The final report will then, considering the public comment received and comments from the advisory committee that we formed, will then be presented to the State Water Board as the final report from the expert panel. And of course, I want to do that all in about 4 to 5 months, but realistically, we'll have to work on the schedule a little bit. I know this is important to get these answers quickly because we are in the midst of regulating and want to continue to do that. At the same time, we don't want to wait too long. So finding that balance to go as quick as we can but have good results will be a tricky point, but we will try our best. And any questions on that?
Will you be possibly rolling out the findings of the panel over time? I mean, there may be some actions that they could take early and let us know what they think, or is it going to all be packaged? Because you've as you said, you've put a lot on their plate. So have you considered that they might come out with chapters, if you will?
That's certainly a good comment, and we'll have to contemplate whether that, when we get the questions, certainly we can consider something along that effect. That's very, very good suggestion. Thank you.
Or could you comment on the role of the regional boards within that framework? Where we would get their input and.
Right. So I definitely would like to have the regional boards participate on the advisory committee. And then again, this is a completely open process. So even if they're not choosing to participate on the advisory committee, then they would be available to provide comments all the way through the public process. It's, we want to put basically all parties on equal standing before the expert panel so that they basically get to weigh everybody's opinion equally.
I know I've asked you this, but I can't remember the answer. What's your sense of the size of the panel?
I've budgeted for up to 10 people. I would like it to be as small as possible while still covering the necessary expertise. And so some of that will come from the contractor's recommendation as to when they kind of do their survey work and see the questions that we're proposing, what kind of expertise they think they need associated with that. So somewhere in probably, I would imagine it could not be less than 6. Up to 10 is where I'm targeting at the moment.
Right. Thank you. Go ahead.
A little more information on timing. How long do you think before, so the advisory committee would have to be established and you'd have to get recommendations from them first?
Well, there's some stuff that's definitely overlapped. We can do the advisory committee while we're working on that, while the contractor's doing some survey work and stuff. Right now, I tentatively have a very tight schedule of the contractor delivering a final report to the State Water Board, I believe, at their first April board meeting. But that's pretty rough, and I need to work through it. So that's where we're targeting for speed-wise to go, and I'll have to report to you how successful we are and when we get stuff together on that.
So if someone is interested in being on this advisory committee,
Yes, I'm
what should
already
they do?
Yes,
Yeah, we're getting-
thank you, Board Member Spivey
Should
Weber.
I
I'm
give your
already
home
getting.
number?
Yeah, no. So I certainly
Twitter
will
is
take
alive with
anybody's
suggestions.
comments now, and I have gotten some, recommendations on folks and whatnot, and I'm collecting those. But don't worry, you don't have to like rush to do it now. We will publicly announce a call on our LIRIS lists and stuff like that we would like to solicit input, so that I can get that to the contractor for their consideration. So I'll try to make sure everybody knows for sure when it's happening. If you feel compelled to do it now, certainly I can hold that information until that time, if someone sends it to me or sends it in.
Thank you.
I have a couple of more things.
Right, back to you.
We have one procedural matter that I wanted to touch on. Petitioners, growers, shippers submitted objections late yesterday to some of the comments that were submitted on this matter, including references to the UCD nitrate report, comments addressing the State Water Board's obligation to consider AB 685's human right to water and to consider the state's anti-degradation policy, which had not been raised before the State Water Board in the petitions or responses, and comments related to approval of cooperative groundwater monitoring plans subsequent to adoption of the agricultural order. We do not propose to resolve the objections at this time. We propose to allow commenters to discuss studies that are not part of the administrative record in the proceedings, including the UCD nitrate report, but we note that we cannot rely on those studies in resolving the issues because they are not part of the administrative record. Also, for purposes of today's workshop, we will allow commenters to discuss the additional policy and legal arguments raised in their comment letters, but we will consider and resolve the objections subsequent to today's workshop concurrently with preparation of the final order, the proposed final order.
Great.
So I
That
think
seems
we're ready
right.
to proceed to the workshop. I'll go through the order that we had announced. The parties will speak in the following order. We're starting with the Central Coast Water Board, 30 minutes. The agricultural petitioners have 1 hour, and I understand that they will be allocating that time approximately as Ocean Mist has 15 minutes, Farm Bureau and Grower Shipper collectively 40 minutes, and Jensen Family Farms 5 minutes. They're free to allocate it however they deem appropriate. The environmental petitioners then have 30 minutes. After the parties, an environmental justice panel will speak for 30 minutes, and a panel headed by the Department of Food and Agriculture will speak for 20 minutes. We will then call interested persons to speak. If you intend to speak, please fill out a speaker card and give it to the clerk, to the board. And finally, the parties will then have an opportunity to respond to the presentations and speakers for 5 minutes each in the following order: the environmental petitioners first, the agricultural petitioners second, and the Central Coast Water Board third. And the board members and staff may ask questions at any time during the proceedings. So unless you have any questions, we'll call up the Central Coast Water Board.
That seems fine. And as I'm seeing, you're saying you want the public comment before the rebuttal.
Yes.
Okay.
That's what we
No,
decided.
that seems good.
So
And the
have everybody-
rebuttals.
The parties come back at the end.
Just the parties, right. And we'll definitely take lunch during that. I think hard to get through an hour and a half estimate. 1:30 is a little bit late for lunch. So my question would be for the ag petitioners, if you mind, if we take your preference about continuing on till you're through before we take lunch, or taking lunch in the middle of your presentation. I can't hear you, but I know you're thinking. The middle is fine, thank you, and the rest of the room thanks you as well. So we'll count on taking a break at, we'll just see, maybe the middle of the agricultural presentation, somewhere either, not necessarily 1, but before 1:30, depending on where we are. Okay, thank you. I hope you've brought your provisions, in case you need. I have some here in case anybody really needs food before we break. All right, let's turn to the Central Coast Water Board, and the timer is set. And thank you for filling out these cards, too. In fact, I will let you introduce your panel as opposed to...
Okay, hello, Madam Chair and board members. My name is Frances McChesney. I'm attorney in the Office of Chief Counsel. And with me today are my colleagues, Lori Oken and Jessica Yar. And in addition, I have Michael Thomas and Angela Schroeder and Monica Barakart, who are staff of the Regional Water Board. Thanks very much for giving us the opportunity to speak on the draft order. What I would like to do is I'm going to make a few points regarding some legal issues, and then Mr. Thomas and Ms. Schroeder will talk about some of the technical issues regarding your draft order.
Great. Before you start, something I wanted to remind people, I said it this morning, but there may be some people who, or at the beginning, there may be some people who came in a little bit later. This is a workshop hearing. We will not be making a decision today on this item. We're all ears and listening. By the time we give you our next draft order, we will have reviewed all of the written comments, really thoughtfully considered all the comments that we hear today, and as Ms. Wadhwani said, you will have another written opportunity to further tell us whether we got it right or where we did or didn't get it right and what we ought to consider before we go to the formal adoption hearing. So I think it's a very full process and appreciate it. I just want to remind people that we're taking it all in today and not making the decision. So that's actually better, I think, in terms of being able to fully listen. So thank you.
And I just want to add that all of us are available to answer any of your questions. So the first point I wanted to make was that in reviewing the Jensen Family Farms and William Elliott petition, Mr. Jensen and Mr. Elliott asserted that the regional board did not consider economics in adopting the waiver. And I just wanted to, as required by Water Code Section 13241. And I just want to point out that Section 13241 does not directly apply to the adoption of waivers, which is under 13269. However, the board, in fact, did consider economics and costs quite extensively and prepared a detailed document evaluating the costs of compliance with the order, including the costs. They make a particular point about buffers and included detailed discussion of costs of complying with buffer provisions. And also, the board evaluated costs that, to the extent required by the California Environmental Quality Act. That document where they evaluate costs is Appendix F of the board, I think it's appendix to the resolution adopting the order. And in addition, the regional board, as you know, the regional board's proceeding was very lengthy, and the board heard comments over many, many months regarding costs, and did, over that lengthy proceeding, make changes to the order, drafts of the order, to address some of the cost considerations and concerns raised by the parties. The other area that I wanted to comment on is having to do with the issue of compliance and enforcement of the waivers conditions. And during the course of the proceeding, the regional board heard many comments concerning, or raising concerns that upon adoption of the waiver, that growers and dischargers would be immediately in non-compliance with the water quality objectives and standards in the waiver. And the board was, wanted to make clear in the order that they understood that it's not likely to have immediate compliance with water quality objectives, included various provisions in the order to address that. But from the comments on your draft order, it appears that there's still some concern about that issue. What the regional board did was make very clear that they do intend the dischargers to comply with water quality objectives, but recognize that that would be through an iterative process of implementing management practices, evaluating them, monitoring, submitting reports, and then, adjusting or implementing new management practices if it appeared that those were not being effective in achieving water quality objectives. The regional board was very intentional in doing that and in assuring compliance with the water code and the state water board's non-point source policy. And but as I said, there's still some concern, it appears, about that. Both the water code and the non-point source policy make clear that the purpose of a non-point source program is to achieve water quality objectives, protect beneficial uses, and comply with any degradation policies. The non-point source policy has 5 key elements for achieving, that go towards achieving the water quality objectives, and the board addressed each of those elements in their order, the regional board. And I'm going to just talk about 3 of those key elements. The first key element states that the purpose of a waiver is to assure that non-point source discharges are addressed in a manner that achieves and maintains water quality objectives and beneficial uses and the anti-degradation policies. The second key element contemplates that dischargers may use management practices rather than numeric effluent limits to achieve the purpose of the waiver, that is to comply with water quality objectives. And the key element number 4 specifically requires that there's sufficient feedback mechanisms for the regional board and the dischargers and the public to evaluate whether they are achieving those objectives. The dischargers, according to key element number 4, are to engage in an iterative process of implementing management practices, then evaluating whether they are being effective, such as through reporting, inspections, monitoring, and other activities, then implement newer revised management practices as needed. The feedback process is stated in the NPS, in the non-point source policy, as an integral part of implementation. The regional board intended that its order be implemented consistent with the non-point source policy, use of the management practices, the feedback mechanisms, and including evaluation of the management practices. And like I said, it includes several findings as well as milestones to achieve those, the purpose of complying, ultimately achieving water quality objectives. The regional board is concerned that some of the changes in the draft order would undermine that process by not allowing some of the feedback mechanisms that were intentionally included in the order to make sure that management practices are actually being effective. And that some of the commenters want to delete even more of those and delete some of the other mechanisms that the board chose to put into the order to be able to evaluate management practices, make sure the public and the regional board and the dischargers get the information to help them to make sure the management practices are focused on protecting water quality. And in some cases, the draft order removes some of the key conditions. Anyway, so we proposed some changes. We made comments regarding some of those conditions, and Mr. Thomas and Ms. Schroeder will talk further about the specifics. But I did want to point out, too, that as you can see from our comments, we didn't support the proposed language in the draft order that would equate good faith efforts to be the same as compliance. And because we believe that that provision would, that statement would not be consistent with the non-point source policy or the water code. The non-point source policy states, and I quote, "Although management practice implementation never may be a substitute for meeting water quality requirements, management practice implementation assessment may in some cases be used to measure non-point source control progress." So the regional board did intend to use an iterative process of the management practices to achieve objectives, but not to be a substitute for complying with objectives. That said, we proposed some language, but in reviewing it today, I realized that we made an error, and I would like to correct that error. And we sort of combined the language in the draft order with our proposed language and messed up, basically. So the part, just so you know, is on page 4 of our regional board comments. We proposed some language to replace the language in your page 45 of your order. And all we want to do is change the first, it says to be considered in compliance, and we want to change that to achieve compliance, consistent with the non-point source policy language.
What page is that on our order?
It's on page 45 of your order and page 4 of our regional board comments. And your order, we didn't do a red line strike out of your language because we proposed kind of a whole substitute, but we sort of borrowed some of it and changed the point of our proposal.
All right, so it makes more sense to write it on your proposal.
Right,
Staff, you have those, the changes she just said?
I've added what Ms. McChesney just gave us to the comment that they had given us, so we know the changes. And I'm correct that you're proposing this as a substitute for our bolded underline language,
Right,
not
so-
for all of 82.
Right, so so your substituted, your language on page 45 that says add this to its paragraph 82, we would substitute our paragraph in place of
Okay,
that.
thanks.
Excuse me, I'm looking at it now, I just want to make sure. So instead of to be considered in compliance, you've
Yes,
got to
to
achieve
achieve
compliance.
compliance.
All right.
And basically, then they would be considered in compliance if they engage in the iterative process. So the board could, in a subjective way, objective way, they could look at, did they have a farm plan that shows the management practices they're doing? Have they evaluated those, and have they improved those? So you could look at those without regard to their good faith efforts or not good faith efforts, just did they do that or didn't they do that? And the point of that is to then ultimately achieve water quality objectives. The other thing I wanted to point out is in your draft order on page 7, you discuss, this has to do with Board Member Johnston's addition to the draft, to the Regional Board's order. And on page 7, in the first paragraph, it makes the statement that Board Member Johnston introduced his proposal during board member deliberations as an alternative to adopting the agriculture proposal. And the Regional Board does not believe that that's an accurate statement regarding the purpose of Mr. Johnston's proposal. Mr. Johnston's proposal was an addition, or followed provision 10, which says that the board I can't quote exactly, but acknowledging the use of third-party groups to implement the order, and that the purpose of this Board Member Johnston's language, which is paragraph provision 11, is to say that if agriculture groups formed a group, that there would be a technical advisory committee to review those proposals. So it's our position that it was not proposed as an alternative to the ag proposal, but rather an option to assure evaluation of group proposals. In addition, so the primary focus was on the technical advisory committee, which was discussed quite frequently during the course of the proceeding. So in your statement on page 9, you stated that Board Member Johnston's proposal was a direct outgrowth of the extensive comments received on the proposed agricultural order. That's probably true, but it was also comments specifically about the use of technical advisory committees. So I just wanted to point out those inconsistencies with the record. And then on page 8, the draft order, your draft order says that it was drafted as a compromise for the third-party approach. And again, I don't think that accurately reflects the purpose of Mr. Johnston's proposal. And then the last comment I wanted to make before I turn over to Mr. Thomas is, well, maybe